Section 218, Injunction or declaration in the event of illegal or irregular activity. 1. The court on the application of a member may by injunction restrain the company a. From doing an act or entering into a transaction which is illegal or beyond the power or capacity of the company or which infringes a provision of the constitution of the company, or b. From acting on a resolution not properly passed in accordance with this act or the constitution of the company, and may declare that act, transaction or resolution already done, entered into, or passed to be void. 2. Subsection 1 does not derogate from the protection afforded by a provision of this act to a person dealing with the company. 3. In relation to acts beyond the capacity or power of the company, this section is subject to Section 19 and does not limit its application. 4. The right afforded to a member to apply to the court does not limit the right that member may have to institute proceedings against a director of the company pursuant to Section 200 or to apply to the court under Section 219. 5. In proceedings by a member under this section, the court may order the member to give security for the cost of the company and may direct that the application shall be heard in chambers. Section 219, Remedy against oppression. 1. A member or debenture holder of a company or, in a case falling within Section 234, the registrar may apply to the court for an order under this section on the ground that a. The affairs of the company are being conducted or the powers of the directors are being exercised in a manner oppressive to one or more of the members or debenture holders or in disregard of the proper interest of those members, shareholders, officers, or debenture holders of the company. Or b. An act of the company has been done or is threatened or that a resolution of the members, debenture holders, or a class of them has been passed or is proposed which unfairly discriminates against, or is otherwise unfairly prejudicial to, one or more of the members or debenture holders. 2. Where on the application, the court is of opinion that either of the grounds set out in subsection 1 is established, the court may, with a view to bringing to an end or remedying the matters complained of, make an appropriate order, and, without limiting the effect of this subsection, the court may by order a. Direct or prohibit an act or cancel or vary a transaction or resolution. b. Regulate the conduct of the affairs of the company in future. Or c. Provide for the purchase of the shares or debentures of any members or debenture holders of the company by other members or debenture holders of the company or by the company itself, and in the case of purchase of shares by the company without regard to the limitations imposed by sections 61 to 65, other than subsections 4, 5, and 6 of section 61. 3. Where an order under this section makes an amendment in or addition to any provisions of the constitution of a company, then, despite anything in this act but subject to the provisions of the order, the company shall not without the leave of the court, make a further amendment in or addition to the Constitution inconsistent with the provisions of the order. 4. An official copy of an order under this section amending or adding to the Constitution of the company shall, within 28 days after the making of the order, be delivered by the company to the registrar for registration. 5. Where a company defaults in complying with subsection 4, the company and an officer of the company that is in default is liable to pay to the registrar an administrative penalty of 250 penalty units. 6. On an application under this section by a member or debenture holder of the company, the court may order the applicant to give security for the cost of the company and may direct that the application shall be heard in chambers. Section 220. Member requiring company to purchase shares. 1. Despite Section 64 and 65, a member may require a company to purchase the shares of that member where members of a company by special resolution resolve to a. Amend the constitution of the company with a view to varying or dispensing with the business activities or objects of the company. b. Approve 1. A major transaction under Section 145. 2. An arrangement, compromise, merger or division of the company under Part T of Chapter 2 of this Act. Or 3. The variation of class rights under Section 50. 2. A sale and distribution in pursuance of a special resolution under subsection 1 is binding on the company. 3. A member of the company is entitled to have the shares of that member bought under the provisions of this Act, only if that member voted wholly against the resolution for matters specified in subsection 1. 4. A special resolution pursuant to paragraph A and paragraphs B, I, 2, and 3 of subsection 1 may only be rescinded by a special resolution. 5. For the purposes of A. Subsection 2. If within 1 year from the date of the passage of the special resolution, the company has been unable to carry out the proposed objects or any of the business activities specified in paragraph B of subsection 1, a member is entitled to apply to have the respective shares reinstated. And B. This section, a special resolution, is deemed to include, in the case of a variation of class rights, the prior written consent of the holders of at least 3/4 of the issued shares of the class of shares affected. Skip sections 221, 222, 223, 224, 225, 226 and 227. Section 238, Arrangement or merger by sale of undertaking. 1. Despite any other provisions on arrangements or mergers in this Act, a company may, with a view to effecting an arrangement or merger, resolve by special resolution that A. The company be put into a voluntary liquidation of members, and B. The liquidator be authorized 1. To sell the whole or part of the undertaking or assets of a company to another body corporate, whether a company within the meaning of this Act or not, in this part called the transferee company, in consideration or part consideration of fully paid shares, debentures or other like interest in the transferee company, and 2. To distribute those shares, debentures or other like interest in specie among the members of the company in accordance with their rights in the liquidation. 2. A sale and distribution in pursuance of a special resolution is binding on the company and the members of the company, and each member shall be deemed to have agreed with the transferee company to accept the fully paid shares, debentures, or other like interest to which that member is entitled under the distribution. 3. For the purposes of subsection 2, if A. Within 1 year from the date of the passage of the special resolution, an order is made under Section 219 or for the winding up of the company under the body's Corporate, Official Liquidations, Act, 1963, Act 180, the arrangement or merger and the sale and distribution shall not be valid unless sanctioned by the court. Or B. A member of the company, by notice in writing addressed to the liquidator and left at the registered office of the company within 28 days after the passage of the resolution, dissents from the arrangement or merger in respect of all of the shares held by that member, the liquidator shall abstain from carrying the resolution into effect or shall purchase the shares at a price to be determined in a manner provided by subsections 4, 5, and 6 of this section. 4. Where the liquidator elects to purchase the shares of a member who has expressed dissent in accordance with subsections 2 and 3 of this section, the price payable for the shares shall be determined by agreement or, in default of agreement, by a single arbitrator appointed by the Institute of Chartered Accountants in the country in accordance with the Alternative Dispute Resolution Act, 2010, Act 798. 5. The price shall be determined by estimating what the member concerned would have received had the whole of the undertaking of the company been sold as a going concern for cash to a willing buyer and the proceeds, less the cost of liquidation, been divided amongst the members in accordance with their rights. 6. The purchase money shall be paid before the company is dissolved and raised by the liquidator in the manner that may be determined by the special resolution or, in default of a direction in the special resolution, in the manner that the liquidator thinks fit as part of the expenses of the winding up. 7. This section does not authorize a variation or an abrogation of the rights of the creditors of the company. 8. If a company otherwise than under this section, a. sells or resolves to sell the whole or a part of the undertaking or assets of the company to another body corporate in consideration or part consideration of shares, debentures, or other like interest in that body corporate, and b. resolves to distribute the proceeds in specie among the members of the company, whether in a liquidation or by way of dividend, a member of the company may, by notice in writing addressed to the company and left at the registered office of the company within 28 days after the passage of the resolution authorizing the distribution, require the company to abstain from carrying the resolution into effect or to purchase any of the shares of that member at a price to be determined, in the manner provided by subsections 4, 5, and 6. 9. Subsection 8 does not authorize a company to a. purchase the shares of the company except in accordance with sections 61 to 66, or b. make a distribution to the shareholders except in accordance with section 72 and section 75 to 82 or in a liquidation. Section 239, Arrangement or compromise with court approval. 1. Where an arrangement or compromise is proposed between a company and the creditors, or any class of the creditors, or members, or any class of members of the company, the court, on application of a. the company or a member or creditor of the company, b. the liquidator in the case of a company being wound up, c. the administrator where an administration order in relation to the company is still in force, or d. any other person interested in the matter may order the meetings of the various classes of members and creditors be summoned in the manner that the court directs. 2. Where a majority in number, representing 75% in value, of each class of members concerned and a majority in number representing 75% in value of each class of creditors concerned approve the arrangement or compromise, the approval shall be referred to the registrar by the persons concerned. 3. The registrar shall recommend to the court the appointment of a reporter who shall be a qualified insolvency practitioner to investigate the fairness of the arrangement or compromise. 4. The remuneration of the reporter shall be fixed by the registrar and the proper expenses of the investigation shall be borne by the company or any other party to the application that the court orders. 5. Where the court, after considering the report, makes an order confirming the arrangement or compromise, with or without modifications, the arrangement or compromise as confirmed is binding on the company and on all members and creditors of the company and its validity shall not subsequently be impeachable in any proceedings. 6. On the hearing by the court of the application to confirm the arrangement or compromise, a member or creditor of the company claiming to be affected by the arrangement or compromise is entitled to be represented and to object. 7. The court may prescribe the terms that the court considers fit as a condition of its confirmation, including a condition that any member shall be given rights to require the company to purchase the share of the company at a price fixed by the court or to be determined in a manner provided in the order. 8. Where the court is satisfied that the arrangement or compromise involves the transfer of the whole or part of the undertaking or assets of a company to another company, the court may a. exercise its powers under Section 240 or 255, or b. order the transfer in accordance with this part. 9. An arrangement or compromise may be carried out in accordance with this section although it could have been accomplished under Section 238 or any other provision of this Act. 10. Despite subsection 9, Section 78 to 82 shall also be complied with if the arrangement or compromise is one which, by virtue of Section 78, requires the confirmation of the court in accordance with those sections. 11. An order made under subsection 5 of this section shall not have effect until a certified true copy of the order has been delivered to the registrar, who shall register the order and publish it in the company's bulletin. 12. A copy of the order shall be annexed to every copy of the constitution of the company issued by the company after the order has been made. 13. If a company defaults in complying with subsection 12, the company and every officer of the company that is in default is liable to pay to the registrar an administrative penalty of 25 penalty units in respect of each copy issued contrary to subsection 12. Section 240. Powers of the court in facilitating arrangements or compromise. 1. Where an application is made to the court under Section 239 and the court is satisfied that under the arrangement or compromise the whole or a part of the undertaking or assets of a company, in this section referred to as a transferor company, is to be transferred to another company, in this section referred to as the transferee company, the court may, by the order sanctioning the arrangement or compromise or by a subsequent order, make provision for all or any of the following matters. A. The transfer to the transferee company of the whole or a part of the undertaking, assets and liabilities of the transferor company. B. The allotting or appropriation by the transferee company of shares, debentures or other like interest in that company which, under the arrangement or compromise, are to be allotted or appropriated by that company to or for a person. C. The continuation by or against the transferee company of legal proceedings pending by or against a transferor company. D. The dissolution, without winding up, of a transferor company. E. The provision to be made for any person who, within the time and in the manner that the court directs, dissents from the arrangement or compromise, or F. The incidental, consequential and supplemental matters that are necessary to secure that the arrangement or compromise is fully and effectively carried out. 2. Where an order under subsection 1 provides for the transfer of property or liabilities. A. That property shall, by virtue of the order, be transferred to and vest in. And B. Those liabilities shall, by virtue of the order, be transferred to and become liabilities of the transferee company, and in the case of a property, if the order so directs, shall be freed from a charge which, by virtue of the arrangement or compromise, is to cease to have effect. 3. Where an order is made under subsection 1, a company in relation to which the order is made shall deliver a certified true copy of the order to the registrar for registration within 28 days after the making of the order. 4. Where the company defaults in complying with subsection 3, the company and every officer of the company that is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the default continues. 5. In this section, property includes property, rights and powers of every description, and liabilities includes duties of every description, although the rights, powers and duties are of a personal character which could not under the general law be assigned or performed vicariously. Section 241, Mergers. 1. Sections 259 to 274 do not apply where a company, in respect of which an arrangement or compromise is proposed, is being wound up. 2. Two or more companies referred to in sections 259 to 274 as the merging companies may be parties to a merger as defined in this Act and continue as one company. 3. In sections 259 to 274, a reference to a merging company is A. In relation to a merger by absorption, to the transferor and transferee companies. And B. In relation to a merger by formation of a new company, to the transferor company. Section 242, Merger Proposal. 1. A merger proposal shall set out the terms of the scheme and provide at least for the following. A. In respect of each transferor company and the transferee company, 1. The name of the company, 2. The address of the registered office of the company, and 3. The type of company. B. The number of shares in the transferee company to be allotted to members of a transferor company for a given number of their shares referred to as the share exchange ratio. C. The amount of any cash payment. D. The terms relating to the allotment of shares in the transferee company. E. The date from which the holding of shares in the transferee company will entitle the holders to participate in profits, and any special conditions affecting that entitlement. F. The date from which the transactions of a transferor company are to be treated for accounting purposes as being those of the transferee company. G. Any rights or restrictions attaching to shares or other securities in the transferee company to be allotted under the scheme to the holders of shares or other securities in a transferor company to which any special rights or restrictions attach, or the measures proposed concerning them. H. The name of the transferee company where it is the same as the name of one of the merging companies. 1. The full name and residential address of each director and the secretary of the transferee company. J. The address for service of the transferee company. K. The shareholding structure of the transferee company, specifying the 1. Number of authorized shares of the company, and 2. Rights, privileges, limitations, and conditions attached to each share of the company. L. The manner in which the shares of each transferor company are to be converted into shares of the transferee company. M. Where the shares of a transferor company are not to be converted into shares of the transferee company, the consideration that the holders of those shares are to receive instead of shares of the transferee company. N. Any payment to be made to a member or director of the transferor company, other than a payment of the kind described in paragraph M. O. Details of any arrangement necessary to complete the merger and to provide for the subsequent management and operation of the transferee company, and P. A copy of the proposed constitution of the transferee company, if any. 2. A merger proposal may specify the date on which the merger is intended to become effective. 3. Where the shares of one of the merging companies are held by or on behalf of another merging company, the merger proposal shall a. Provide for the cancellation of those shares without payment or for any other consideration when the merger becomes effective. And b. Not provide for the conversion of those shares into shares of the transferee company. Section 243. Approval of merger proposal. 1. The directors of each of the merging companies shall resolve that a. In their opinion, the merger is in the best interest of the company. And b. The directors are satisfied on reasonable grounds that the transferee company shall be solvent immediately after the merger becomes effective. 2. The directors who vote in favor of a resolution under subsection 1 shall sign a certificate stating a. That, in their opinion, the conditions set out in that subsection have been satisfied, and b. The grounds for the opinion of the directors. 3. The directors of each of the merging companies shall send to each member of the transferor company, not less than 28 days before the merger is proposed to take effect, a. A copy of the merger proposal. b. Copies of the certificates given by the directors of each transferor company. c. A summary of the principal provisions of the constitution of the transferee company, if any. d. A statement that the copy of the constitution of the transferee company shall be supplied to any member of the company upon request. e. A statement setting out the rights of members pursuant to the merger, including the number of shares in the transferee company to be allotted to members of a transferor company for a given number of their shares and the amount of any cash payment. f. A statement of any material interest of the directors in the proposal, whether in that capacity or otherwise. And g. Any other information and explanation that may be necessary to enable a member of the company to understand the nature and implications for the transferor company and its members of the proposed merger. 4. The directors of each transferor company shall, not less than 28 days before the merger is proposed to take effect, a. Send a copy of the merger proposal to every secured creditor of the company. And b. Give public notice of the proposed merger, including a statement that a. Copies of the merger proposal are available at the registered offices of the merging companies and at any other place as may be specified during normal business hours, for inspection by a member or creditor of a merging company or any other person to whom a merging company owes the obligation. And 2. A member or creditor of a transferor company or any other person to whom a merging company owes an obligation to supply a copy of the merger proposal is entitled to be supplied, free of charge, with a copy of the merger proposal upon request to a merging company. 5. The merger proposal shall be approved by a majority in number, representing 75% in value, of each class of A. Members of each of the merging companies, present and voting either in person or by proxy at a meeting. B. Creditors of each of the merging companies, and C. Members or an interest group where the merger proposal or the constitution of a transferor company requires the approval of that class of members or interest group. Section 244, Short Form Merger. 1. A company and one or more other companies that are directly or indirectly wholly owned by the company may merge and continue as one company without complying with Section 259 or 261 where A. The merger is approved by a resolution of the directors of each of the merging companies, and B. Each resolution provides that the 1. Shares of each merging company, other than the transfer company, shall be cancelled without payment or other consideration. 2. Constitution of the transferee company shall be the same as the constitution of the transferor company. And 3. Directors of each of the merging companies are satisfied on reasonable grounds that the transferee company shall be solvent immediately after the merger becomes effective. 2. Two or more companies, each of which is directly or indirectly wholly owned by the same company, may merge and continue as one company without complying with Section 259 or 261 where A. The merger is approved by a resolution of the directors of each of the merging companies. And B. Each resolution provides that I. The shares of all but one of the merging companies shall be cancelled without payment or other consideration. 2. The constitution of the transferee company shall be the same as the constitution of the merging company whose shares are not cancelled. And 3. The directors are satisfied on reasonable grounds that the transferee company shall, immediately after the merger becomes effective, satisfy the solvency test. 3. The directors of each of the merging companies shall, not less than 28 days before the merger is proposed to take effect, give written notice of the proposed merger to every secured creditor of the company. 4. The resolutions approving a merger under this section, taken together, shall be deemed to constitute a merger proposal that has been approved. 5. The directors who vote in favor of a resolution under subsection 1 or 2, as the case may be, shall sign a certificate stating a. That, in their opinion, the conditions set out in subsection 1 or 2 are satisfied, and b. The grounds for the opinion of the directors. 6. A director who fails to comply with subsection 5 is liable to pay to the registrar an administrative penalty of 350 penalty units. Section 245, Registration of Merger Proposal. For the purpose of effecting a merger, the following documents shall be delivered to the registrar for registration. A. The approved merger proposal. B. Any certificate required under subsection 2 of Section 244 or subsection 5 of Section 245. C. A certificate signed by the directors of each transferor company stating that the merger has been approved in accordance with this Act and the Constitution of the company, if any. D. Where the transferee company is a new company or the merger proposal provides for a change of the name of the transferee company, a copy of the notice reserving the name, if any, of the company. E. A certificate signed by the directors, or proposed directors of the transferee company stating that, where the proportion of the claims of creditors of the transferee company in relation to the value of the assets of the company is greater than the proportion of the claims of creditors of a transferor company in relation to the value of the assets of that transferor company, no creditor shall be prejudiced by that phase. F. A document in the prescribed form signed by each of the persons named in the merger proposal as a director or secretary of the transferee company consenting to act as a director or secretary of the company, as the case may be. And G. A report regarding the fairness of the merger and issued by an insolvency practitioner appointed by each company unless dispensed with under Section 247. Section 246, Approval of Constitution of Transferee Company formed from a merger. A transferor company shall approve by ordinary resolution the constitution or draft constitution of a transferee company that is a new company. Section 247, Exemption from publication of reports and other requirements of law. 1. The court may, on the application of a merging company, a member of a merging company or a creditor of a merging company, exempt that merging company from the publication of the report, issued by an insolvency practitioner pursuant to paragraph G of Section 245, or any other requirement under this Act if the court considers it appropriate. 2. Despite subsection 1, the requirement for a report issued by an insolvency practitioner may be dispensed with only if the merging companies agree in writing to the dispensation. Section 248, Certificate of Merger. 1. The registrar shall, within 7 days from the date of receipt of the documents referred to under Section 245. A. In the case of a merger by absorption, issue a certificate of merger. Or B. In the case of a merger by formation of a new company, 1. Enter the particulars of the transferee company in the register, and 2. Issue a certificate of merger together with a certificate of incorporation. 2. Where a merger proposal specifies a date on which the merger is intended to become effective, and that date is the same as or later than the date on which the registrar receives the documents, the certificate of merger and certificate of incorporation issued under subsection 1 shall be expressed to have effect on the date specified in the merger proposal. Section 249, Effect of Certificate of Merger. 1. A merger shall be effective on the date shown in the certificate of merger. 2. Where the name of the transferee company is the same as one of the merging companies, the transferee company shall have the name specified in the merger proposal. 3. Subject to subsections 4 and 5, the registrar shall dissolve, without winding up, the merging companies other than the transferee company retained under subsection 2. 4. The property, rights, powers, and privileges of each of the merging companies which have been dissolved under subsection 3 shall continue to be the property, rights, powers, and privileges of the transferee company. 5. The transferee company shall continue to be liable for the liabilities and obligations of each of the merging companies, and a proceeding instituted by or against a transferor company shall be continued by or against the transferee company. 6. A conviction, ruling, order, or judgment in favor of or against a transferor company may be enforced by or against the transferee company. 7. A provision of the merger proposal that provides for the conversion of the shares or rights of members in the merging companies shall have effect in accordance with the tenor of the merger proposal. Ends here.